Thank you for joining us. The following presentation is from my webinar titled, Not Your Grandfather's Corporate Trustee, Modern Trust Laws and the Resurgence of the Corporate Trust. Originally produced on November 18th. The presenter is David Warren from the Bridgeford Trust Company. Enjoy the presentation and visit us online at www.macpas.com for information about our future events and upcoming webinars.
Thanks, Tyler. Again, my name is David Warren. I am a president and CEO of Bridgeford Trust Company. Happy to be here today. We have some, I believe, to be pretty exciting topics to talk about. And, you know, a lot of you may have noticed the title, Not Your Grandfather's Trustee, is kind of a play on words of the Oldsmobile commercial, which absolutely applies here. We're going to be talking about a lot of different concepts that make current trustees and the current trust space so much different and so much more dynamic and deliver so much more control to advisors in the planning process that it really is not your grandfather's trust company or trustee anymore. As I said, my name is David Warren, and with Bridgeford Trust Company, before starting Bridgeford about 2.5 years ago, I had practiced law in the area and was with various large trust companies. And as we were looking to launch Bridgeford, we paid a lot of attention to what was happening in the trust space and where things were going. And a lot of what we're going to talk about today, and a lot of the reasons why Bridgeford exists at all, is because of certain trends we saw happening in the wealth management and trust space and certain things that we could do now that couldn't be done 20 years ago that make this space actually so much more dynamic and exciting, and the opportunities to provide some cutting-edge planning are available now in ways that were never the case 20 or 30 years ago. So with that, one of the first things that we want to talk about, I think, today as we set the stage for this discussion is sort of a distinction between the corporate trustee and individual trustee. Now, what you see there is some bullet points about comparing the two, but generally, before we get into those, what has happened over the last, I would say, 50 years or 60 years or more, is there has been a bias that is developed in favor of using an individual trustee, which is unfortunate, Tyler, in a lot of ways, because individual trustee, as we'll talk about, is not always the best choice over a corporate trustee. And in fact, I would argue it never is a better choice over a corporate trustee for reasons we'll discuss. But I think it's been an industry response. That is to say, people have gravitated towards using individual trustees over corporate trustees because corporate trustees traditionally have become so difficult to deal with. They have become very rigid. Generally, they are expensive. And when I say corporate trustee, I mean a traditional bank-based trust company. A Wells Fargo, Bank of New York Mellon, PNC, Fulton Bank. A lot of folks are familiar with the trust department of a bank, and that's generally what I'm referring to. As opposed to an individual trustee, which is generally defined as a friend or an uncle or a family member that serves in the capacity of serving as a trustee. And I think, as I started to say, the direction of moving, or people moving in the direction of using an individual trustee over a corporate trustee has been because of so much dissatisfaction. And when we were getting ready to launch Bridgeford, we spent a lot of time, Tyler, talking to people around the country to understand, what was really wrong with this industry and what we could do in building a trust company that could be responsive and that would actually respond to some of the complaints. And what we heard was individual trustees were chosen because they were presumptively less expensive, they were less rigid, they were able to exert more control over the trust by using an individual trustee. But more than that, it was really a backlash of what was really wrong in the corporate trustee space. But when you remove the negativity and sort of look at the facts, as I said earlier, in most cases, I would say in all cases, the corporate trustee is going to make more sense if we could just solve the problems that have been inherent with using a corporate trustee for the reasons that are outlined. I mean, experience. There's no question that professional trustees have a lot more experience, understand fiduciary law, understand the responsibility that comes with being a fiduciary. It's not easy. And especially in today's world, it's become extremely complex. And Uncle Bob or best friend Jim isn't qualified to know the ins and outs of how to administer some of these complicated trusts, some of which we're going to talk about today. Objectivity, one of the biggest things a corporate trust company or a corporate trustee brings to the table is the ability to have no emotion in making its decisions. One of the most important roles of a trustee is to make decisions, distribution decisions, the decisions around who's going to get what. And, if little Johnny says he needs a Lamborghini and Sister Jane got one the year before, well, that, we get into all kinds of arguments about whether that's an appropriate distribution. Well, the corporate trustee provides the objectivity and is able to make a decision, and Uncle Bob, who's serving an individual trustee capacity, is more easily swayed, or more than not, I hear, doesn't want to be in the middle of that conversation because it gets emotional and it gets difficult. Regulation, as we're going to talk about, the regulation around trust companies and trust administration has become so much more complex and multifaceted that the ability to have an organization and a team of professionals to understand these rules has become vitally important. And just continuity of service, to say it bluntly, corporate trustees don't die. I think they get merged into each other sometimes, but they certainly never die. So the reality is, if we remove sort of the bias in favor of individual trustees that was born out of a real dissatisfaction and perhaps failure on the part of corporate trustees around the country, in most cases the corporate trustee makes sense. And so to begin by making that juxtaposition between the corporate trustee and the individual trustee, I want to use that as a foundation to talk about what is really happening in the trust space and why it's so exciting. I mean, there have been more changes in the last 20 years in the trust space that have happened in the last 200 years, and that's people in commentary, writing in commentaries and law review articles that are acknowledging that some of the things that we're going to talk about today have so dramatically changed the way trusts are administered and have brought so much more control back to advisors and people who set up trusts and beneficiaries, that to understand why not only is a corporate trustee traditionally better, but a corporate trustee is in many cases the only way you're going to be able to avail yourself, or families are going to be able to avail themselves of some of the most progressive trust laws in the country. And so I am very excited to talk about a lot of these topics. I certainly welcome questions. As Tyler indicated, there's the ability to do it via, I guess, chat. And so we'll be responsive when we can. So trust jurisdiction matters. This is a very hot topic around the country. I'm very passionate about it. At Bridgeford Trust, we're very passionate about it. Because as we were getting ready to decide where we wanted to have our trust powers based, we started to realize that not all states are created the same, just like not all states are created the same when you decide where to incorporate a new company. Most people would consider Delaware, for example, as the best state to incorporate a company. Well, not a lot of people realize that same analysis applies to where you're going to put your trust. And the fancy legal word is situs, but it's really jurisdiction. And I could tell you, and I've heard this quote said a couple times, several different ways, and I adamantly and absolutely believe it, that the decision as to where to put your trust, that is, which jurisdiction, which state, is as vital and as important as the decision to create a trust in the first place. And so using that as a framework moving forward, we're going to talk about why trust jurisdiction matters, and then we're going to get into the specific, what I believe to be very exciting modern trust laws that deliver more control. You're going to hear me say that a lot in the next hour about how most of what these laws do, what these new laws are been able to do for beneficiaries and people who establish trusts, is they give more control back. And that's what people are asking for. The ultra wealthy families in the country, down to people like you and me, Tyler, who just normal people. We want to have more control, and it's that lack of control, frankly, that have pushed people away from trust planning, because they think that when they set up an irrevocable trust or they do trust planning, they give up control. And quite honestly, that was the case 20 or 30 or 40 years ago. And this idea of giving back more control is just so vitally important and a real common theme of our conversation. So as you see from the slide there, 4 states have sort of ascended to the top of the food chain here when it comes to trust jurisdiction, in no particular order, but South Dakota, Delaware, Nevada, and Alaska have traditionally and consistently been considered top-tier trust jurisdictions, which is to say that they are the jurisdictions that are the most modern, most cutting edge, provide the most tools for individuals to do the type of planning they want, and deliver the most control. And there's that word again, and we're going to hear it a lot, but that deliver the most control in the planning process. And there are certain factors that we'll talk about somewhat quickly as to how these states are. I mean, this top tier is established. Because it's not just my opinion or Tyler's opinion, it's the opinion of some very, very smart people around the country who have compared and done some analysis and have looked at different aspects. And then we're going to transition into a more specific conversation around 3 or 4 very modern and in my opinion, very exciting trust laws. Now I chuckle because people wonder, how anybody can get so excited about trust discussion, Tyler. And I could tell you when I was in law school, I did not like trusts. That was my least favorite class. But right now it's something that actually does get me pretty excited because of all the things we can do.
Yeah, Dave, quick question here for you. I mean, you've obviously had a lot of experience with trusts. From your experience, what percentage of trusts are in the corporate versus the individual trusts? And then how many of those trusts right now are currently taking advantage of these, Tier 1 trust jurisdictions? Thanks,
Tyler. Those are really good questions. I mean, I think the first question is, we have trusts that have been established and have been on the books for in some cases, 150 years. Established at organizations like J.P. Morgan, what has become J.P. Morgan, Bank of New York Mellon, and others. When you look at all of those irrevocable trusts, they were established with corporate trustees. So I think still the vast majority of the old trusts are with corporate trustees. They're not happy to be there. I can tell you that. We'll talk more about that when we go through the program. But I would say, though, in the last 30, 40, 50 years, the majority of new trusts, I think, have been established by virtue of appointing an individual trustee. And what was your second question?
I was just curious about how many of the current individuals who have trusts, individual or corporate, are currently taking advantage of these trust jurisdictions.
Not nearly enough, in my opinion, and I say that with a lot of enthusiasm and passion. This idea of trust jurisdiction and whether it matters and why we need to consider it is a relatively new concept. It hasn't been, probably within the last 15, 18, 20 years, states got smart and said, hey, if we become the most attractive trust jurisdiction, we're going to generate a lot of revenue and we're going to generate new jobs for our state. And so because of that, they were responding. And this is really the exciting part. It isn't so much about revenue to the states that's exciting. What's exciting is some of the wealthiest families in the country said, I've had enough with the corporate trustee structure. I've had enough of not having control. I want to have domestic asset protection. I don't want to have to go to the Cook's Island to get it. So what we see and what we're about to talk about is a direct industry response to what has been traditionally a problem with trust services or corporate trustee services. So when I say not nearly enough, I think there's those of us in the space around the country are very passionate about the conversation of trying to educate people to say, look, you don't have to be in Pennsylvania, for example, if you don't like the limitations in Pennsylvania. I mean, you'll learn as we talk about Pennsylvania doesn't have an asset protection statute, for example. Well, you don't need to be here if you want to avail yourself of an asset protection statute. So we're going to talk about how to move trusts around, but that's a great question. Thank you. So moving somewhat quickly through the factors that that determine which jurisdictions are better. When commentators and lawyers and other industry experts look at this, they look at basically 3 or 4 main areas. Whether a state has an asset protection statute, referred to as a domestic asset protection statute, whether a state taxes trusts or not, whether they impose a income tax or any type of tax on the trust. Privacy rules has become extraordinarily important, and I can tell you, Tyler, a lot of the new clients that we're working with lately at Bridgeford have come to Bridgeford and in South Dakota, which is where we're based, because of their privacy rules, and we'll talk about that in a minute. Rule against perpetuities is a really fancy legal term that really translates into something called a dynasty trust that we'll talk about and define. And then modern trust laws, which is really the purpose of this presentation today, is there are various modern trust laws on the books that have developed over the last 15 years, again, as a direct industry response to what has been perceived as a problem with the trust industry, these modern trust laws have been put on the books in progressive trust jurisdictions like South Dakota, Nevada, Alaska, and Delaware to provide the flexibility and control that we couldn't have before.
Dave, do these factors change between a corporate and an individual trust, or do they kind of remain the same regardless?
Wow, that's thank you for making that distinction. In order to establish jurisdiction in one of these most favorable jurisdictions that we're going to go through, you have to work with somebody that is a resident of that particular state. I put somebody in quotation marks because most people don't have friends in South Dakota. Well, mostly because there's only 3 or 4 people that live there. So I'm just joking, of course. I know there's at least 12. But all joking aside, we don't have an individual friend in Delaware or Nevada in some of these progressive trust jurisdictions, which is why a corporate trustee like a Bridgeford or others that are in these most progressive trust jurisdictions have become so important. So in addition to the factors that I had mentioned before, right, Tyler, about the idea of being able to compare and say, well, in most cases, corporate trustee really does make sense. What makes it even more compelling today than ever is without a corporate trustee, it's very difficult to avail yourself of the advantages of being in a more progressive trust jurisdiction that we're going to talk about. A lot has been domestic asset protection trust. A lot has been written about it. I remember the first time I heard of it when I was still practicing law, sitting in a seminar maybe 18 years ago. Well, maybe not that long ago, but a while ago. These are a direct industry response, as I talked about, of people who didn't want, or families who didn't want to have to go offshore for asset protection. And when I talk about asset protection, I'm talking about protecting assets, all kinds of assets, not just money, not just investable assets or stocks and bonds, but property, closely held stock, artwork, automobiles, anything that can legally be placed in a trust. Particularly wealthy families were looking for a way to keep those assets housed here in the United States and be able to protect them from creditors and, most importantly, really from lawsuits. You know, all of us are a target for a lawsuit, particularly those in the medical profession, business owners. You know, this idea of the deep pocket. You know, everybody is looking for the deep pocket, and here's the problem. There's not a lot of ways to really protect big wealth. I mean, you can certainly get insurance, and that is a tremendous, and I'm a big believer in insurance planning and prudent insurance planning, but you know, these trusts are just another way. It's another way of insurance, I guess, if you will, of being able to establish them. And what makes them so unique, however, and it's important to make a distinction, is these are irrevocable trusts. But they are self-settled, which means that, Tyler, you can establish a self-settled trust. You can put something in trust. And what's most exciting about this is you can still derive a benefit. You can take the income from the asset. So let's say it's a closely held business or it is a stock portfolio. You can still take all the income. You can have a discretionary ability to access the principal. And you have so much more control over your assets and over this trust than you otherwise would have, while getting some really powerful asset protection. And we'll talk a little bit more about how these have been challenged. But there is not a single state or a single court in the country that has struck down an asset protection statute. Now, they've been attacked for different reasons, usually around the idea of fraudulent conveyance, which we'll talk about in a minute. But the statutes themselves have been found to be valid. And we believe in the industry that they are a compelling domestic planning tool for anybody who has a concern about being sued or wants protection from creditors. And creditors, by the way, include future spouses. So we talk a lot about using an asset protection trust instead of a prenup, which carries a lot of advantages, most of which you don't have to tell the intended spouse about it, which people seem to really like. And it's important to note that Pennsylvania does not have an asset protection statute. And I mentioned that earlier. Now, for those of you listening from Pennsylvania or from any state that does not have an asset protection statute, it does not mean you can't have access to an asset protection statute in the United States. And I'll talk a little bit more about that as we go through the program. So as indicated, not every state has them. Right now, only 14 states have passed asset protection statutes. The same 4 states that have ascended to the top of the top tier trust jurisdictions in this country, South Dakota, Nevada, Alaska, and Delaware, They've consistently been recognized as having the most robust and powerful asset protection statutes in the nation. Again, that's not my opinion or Tyler's opinion or the opinion of McKonly Asbury. That's the opinion of some very smart people. And one of the most recent articles was published in the Trust and Estates magazine. Every year they do a comparison of trust jurisdiction. Domestic Asset Protection Trust, as you see, there's a citation there. Feel free to look that up on the internet. That it does a very nice job of explaining why these states are considered the best. Trust and Estates magazine also does a great job every year of just comparing states generally, which is really the framework for a lot of this discussion today.
Dave, another question for you. So I know you've already talked about how trust laws have changed so much, in the past 15 years, and you kind of talk about these specific states who have asset protection statutes. Kind of looking into the future, do you see any other states, kind of taking on those statutes or the laws of states changing? Or do you see Pennsylvania having, some asset protection statutes in the future? What do you see kind of as the future of asset protection, in America 5, 10, 15 years down the road?
I definitely think it's a trend that's going to continue, not only with respect to asset protection statutes, but with regard to modern trust laws generally that we're going to get to. I think states are realizing that they're losing revenue, good revenue by states, by folks moving their trusts to other more favorable states. I know Pennsylvania is absolutely losing revenue because of that, and I would have to imagine at some point the state's going to take a closer look at that. I know that not only has New York State been aware of it, but they've also taken specific steps to stop trusts from leaving by changing some of their laws that make it more difficult to do some complicated and sophisticated trust planning to avoid or to address taxation issues. And New York has been pretty dramatic as of April of this year with a law that basically ignores some of the advantages that you can get from another state, like South Dakota or Delaware. Now, whether those laws stay on the books is a good constitutional question, because I'm not sure that I'm not sure that if those laws work their way to the U.S. Supreme Court, that they'll be supported under their Commerce Clause, because it really is a restriction on trade and other things. And that's, frankly, what a Pennsylvania appellate court has recently said, too, and we'll get to that regarding the taxation issue. But with respect to your specific question, absolutely. I mean, I think states are not only seeing that this is good business for them to attract business, and in South Dakota is probably the best example of that. I mean, they have now Citibank and Wells Fargo and other very large banking institutions have moved their headquarters there for this reason, generating thousands and thousands of jobs. And I joked earlier about how there's not a lot of people in South Dakota. Well, the reality is that the population is really jumping every year, and they're bringing in great jobs, great professionals, very well educated people, and it's been a boon. I mean, Sioux Falls, South Dakota, and Pierre, South Dakota, I've spent a lot of time in. We have an office in Pierre, and they're charming communities that are growing and have good property values, and it's a great place to be. Well, not in February, but I try to avoid going there in February. But generally speaking, that's a very good point. And sure, I expect the trend to continue. I'm a little perplexed why some states haven't changed their laws at this point, but. So taxation, that's a big deal in all types of planning, and in fact, in the early days of trust planning, trusts were developed 200 years ago or 300 years ago as a concept in England, and then Massachusetts, I think, was the first to develop the first trust. It was to pass property of all kinds to the next generation. And what we have heard a lot, at least in modern estate planning and how I was trained in law school, was traditionally people thought of trust planning. It was only available and needed for the ultra wealthy to avoid taxes. And saying to avoid taxes is probably the wrong way to say that, but I'll be blunt about it. People were trying to take advantage of certain exemptions and placing the rest in trusts, and those of us in the industry are very familiar with that. And so taxation really drove a lot of this. And before we talk about taxation, I wanted to make the point that, so much of what we do right now at Bridgeford and what I did as a practicing lawyer had very little to do with taxation in the trust space. People were setting up trusts because they wanted to hold on to control over multiple generations. They wanted to be able to have their legacy pass on, not just financial legacy, but their values. And so what I'm seeing, and those of us in the industry, is taxation is an issue, but it's not the only issue. And in fact, there's some very sophisticated planning that we're doing with a firm in Connecticut and others around the country, that some very, very large trusts are being established, and it has very little to do. It really isn't even an estate planning play at this point. It's more about trying to make sure that the next generation or the subsequent generations don't blow themselves up with this money. And that's a really big deal. Now, having said all that, taxation still is an issue, and it's an important issue to consider. And remember where we are. I'm going through the aspects of what makes one jurisdiction better than another. And taxation is definitely one of them. Some states don't tax trusts. Well, that can be very compelling, particularly in states like California, which have a tremendously high tax rate on income tax for trusts. Now, Pennsylvania, it's still an issue, but less of an issue. It's a little over 3%. But regardless, if there's a way to resituate your trust in a state that can avoid that state tax over the long term, that's pretty compelling. And in fact, vitally important, I think, for advisors to talk about with their clients. And the thing that's becoming exciting is there's a lot of debate right now is, well, how does this work? Well, here's a simple example, Tyler. If you establish a trust and it's a $10 million trust and it sits in Pennsylvania, well, year over year, the undistributed income, which I'm saying income that doesn't get passed to you through the trust, that stays in the trust, is taxed at a little over 3%. But if that same trust was established in Delaware or South Dakota, that state tax doesn't apply, which means that 3% doesn't apply, which means that over time, that adds up to a lot of money. Now, this has been a hotly debated topic, and I just mentioned how New York State responded to it. Pennsylvania also took a similar position as New York initially and said, listen, we don't care where this trust is. If this beneficiary or the settlor lives, well, particularly if the settlor, and when I say settlor, I mean the person who set up the trust, lives in Pennsylvania, we're going to tax them anyway. And so people didn't like that, particularly wealthy families, and said, well, that doesn't seem constitutional. So there's a case, and the citation is McNeil versus Commonwealth of Pennsylvania. Very recent case. I think it was decided or released at the beginning of this year, that essentially says, look, Pennsylvania, if it's a Delaware trust and it meets certain requirements, or if it's a South Dakota trust or any jurisdiction that doesn't apply a state taxation on retained income within a trust, you can't tax it. And you can't tax it because it's a violation of the Commerce Clause, as I mentioned before, which I think is a very smart way of looking at it, and somewhat self-serving because I own a trust company, but I also in another jurisdiction, but also I think it's good law, and it's a good recitation of the law that applies in this circumstance. Now, there's a very, very important distinction to make, and I know that there are lots of folks on this call who are very sophisticated, and so I want to be very, very careful here with what I'm saying. That case in Pennsylvania, and I suspect other states will follow, talks about income, investment income, so stocks and bonds and that type of income cannot be taxed, and here's why. It's not considered Pennsylvania-sourced income because stocks and bonds are held at a custodian elsewhere or nowhere, really. I mean, it's held in cyberspace in some cases, so you really can't establish where that's held. Now, with respect to certain kinds of businesses and certain types of assets that generate income, real estate or whatever, within Pennsylvania, that's a different analysis, and that could be subject to state taxation at the trust level with respect to assets that are income that isn't distributed. People on this call might be wondering, well, why are we making a distinction? Well, it's an important distinction, and I don't want to make the blanket statement, hey, you can avoid taxation entirely by just moving your trust over to another jurisdiction. But I like this trend. I like this trend a lot. And again, I think this type of legal rationale that decided the McNeil case could very likely win the day in New York State once it gets up to the appropriate appellate court level. But nonetheless, again, remember where we are. We're talking about the factors that make a trust jurisdiction important, and this is the taxation piece of it, and something that we're pretty excited about. Privacy, we'll quickly cover this because there's not a lot to say other than to suggest that not all states handle this correctly, or I shouldn't say correctly, I should say the same. I am shocked at how few states actually protect the privacy of these trusts, and what I mean by that is when these trusts end up in litigation, and often they do, as a lot of us on the call know, the contents of the trust can be revealed to the public. That litigation is not sealed. The settlers, the beneficiaries, all of that information can become a matter of public record. And that's a problem for wealthy. It's a problem for all of us, but particularly very wealthy families. And they have decided that's not what they want to happen. So they've put pressure on states to come up with laws that can totally seal this information forever. South Dakota is the only state in the country that seals this information forever. That's a pretty big deal, and I can tell you that has driven families from all over the world into South Dakota, especially with respect to what's happening in Switzerland. You know, Tyler, Switzerland isn't as private as it used to be, and the Department of Justice has really blown a lot of that apart because of terrorism laws and everything else. South Dakota has become and emerged as one of well, particularly domestically, it is the most powerful privacy jurisdiction in the country, which explains, again, why some gigantic dynasty families from around the world have chosen to situs their trust in South Dakota. I was surprised as we launched Bridgeford and began to work with clients and bring new clients on just how important that was. I mean, intuitively we know privacy is important. I just didn't realize how much some of these families were looking for privacy. Delaware, they have a seal, but it's only for 3 years, and then it's open to the public. And in Pennsylvania, as I said before, there is no seal at all. Very, very important issue. Not complicated at all, but another thing that commentators are looking at when they compare these jurisdictions to determine which is a better choice. Dynasty trust. This is I talked about that earlier. You saw, Tyler, that rule against perpetuities, which I'm not even going to begin to try to explain. It's a very arcane legal concept that most people come out of law school and still don't understand. So thankfully, most states are abolishing that rule, maybe for that reason. South Dakota was the first to abolish the rule. And what the rule essentially says, all joking aside, is that at some point in the future, a trust has to terminate. The irrevocable trust has to end, which does what? It means that the federal government can then tax it. Right? That's probably the whole reason why there was such a rule against perpetuities. If a trust can live forever or in perpetuity, another way of saying that means that from generation to generation, the trust never has to end, which means that practically the federal taxation should never apply. Doesn't sound like a revolutionary concept, right? But it really was. And South Dakota was the first to abolish this rule, creating the first dynasty trust. So simply what a dynasty trust is a trust that lives forever. And that is an extremely compelling planning tool. Extremely compelling planning tool for individuals. And again, this just doesn't apply to ultra wealthy. Any individual who has a legacy issue that doesn't want these trusts to be broken apart. So there is no limit. There's no, well, only if somebody who has $20 million this makes sense for. If somebody has $500,000 that's going to grow over the course of 3 generations, that's going to probably turn into a federally taxable estate, or at least potential trust that never has to be broken apart. So what you're going to hear us talk about is dynasty trust states are rated. They're looked at, they're compared, and for the 3rd year in a row, South Dakota has been the leading dynasty trust state for various reasons, which we'll talk about briefly. But this is just another aspect that commentators look at. So this and privacy and whether there's an asset protection statute to determine whether or not, or to determine which state is the best. Directed trust to me is a modern trust law concept that is the most exciting aspect to me, or one of the most exciting aspects to me that's happened, or changes that's happened in the trust world. The directed trust has so dramatically changed the way we approach trusts, and we approach how the trust industry is viewed. And it's a very simple concept. And what's exciting about it is that it was born out of frustration with the traditional trust approach. Tyler, when you hear of having to go to PNC or Bank of New York Mellon, what you hear is that those organizations have always and traditionally, and still do, they're going to want to manage the money. They're going to want to be the trustee and the financial advisor. And frankly, that creates a lot of consternation for folks of any means to say, well, I need a trustee, but I'd like somebody else to be my asset manager. And that's very real right now. And so the idea of being able to have, here's that word again, more control in choosing whom you want to manage your money and be your trustee is what the directed trust is all about. It bifurcates liability. It creates the ability for trustees and investment managers to be two separate entities. Trust companies weren't created, Tyler, just to be asset managers. And I think a lot of people listening today share a similar frustration, which is, just because I need a trustee doesn't mean I want PNC to manage my money. And I'm not at all taking a shot at PNC or any other corporate trustee. But the idea of a trust was to pass property of all kinds across generations, not just investable assets. Now, just because large corporate trustees make a lot of money managing money doesn't make them the best asset managers in the world. So this idea of a directed trust has totally revolutionized the trust industry in a way that makes it very exciting. Most of the work that we do at Bridgeford is in a directed trust space. We don't manage money in-house for this reason, because we think that our clients should have more control to work with the asset managers of their choosing. And it has radically changed the dynamic of how trusts work. And this is, again, one of those modern trust laws that we're now transitioning into that have just changed the whole trust landscape and has opened up the door for trust companies like a Bridgeford to emerge and say, we don't want to be the asset manager. We want to be the expert in trust administration. We want to bring to you the best that the country has to offer in trust laws, and we're going to give you so much more control and flexibility than you've ever had before. And this is, again, what excites me is this is an industry response to a complaint that families have had over the years.
And Dave, just to clarify, so these legal kind of ramifications in regard to directed trust, do they apply, across the board on all states, or is this, again, one of those things where, each state has a different jurisdiction?
Each state has a different jurisdiction. Directed trusts are only available in 6 states right now, Pennsylvania not being one of them. There's some argument in the states without the actual statute that a clever lawyer can draft something that acts and looks and smells like a directed trust. But I think, generally speaking, those of us who spend a lot of time in this space think that's not the right way to do it. So these directed trust statutes are very powerful and require you to be in the right jurisdiction. And it gets back to that point, Tyler, where why does jurisdiction matter? Why does a corporate trustee make sense over an individual trustee? Well, here's our theme again. Without a corporate trustee in a jurisdiction that is progressive enough to have a directed trust statute, you can't have it. So as we said, there's only 6 states in the country that has it, not Pennsylvania. The idea of a directed trust, because the bifurcation of liability opens up something to me that is also very exciting, is that it allows a trust company, it doesn't allow a trust company, it makes a trust company like Bridgeford much more amenable to holding non-traditional assets, which we'll define as closely held stock, LLP interests, real estate, artwork, other types of tangible real property assets, which I can tell you most large corporate trust companies, bank-based trust companies, do not want to deal in. They also don't want to hold insurance policies anymore for various reasons. Probably because they don't make as much money as they'd like to off of them, to be pretty blunt about it. But to be more general and fair, it's because they're worried about their liability. Well, when you bifurcate liability, as the directed trust statute does, it opens the door for companies like a Bridgeford and others around the country who operate as an independent trust company with progressive trust powers to hold assets that traditionally have not been of interest to banks, which raises, again, the concept of the resurgence of the corporate trustee. See, not only do we believe that the corporate trustee in most cases makes sense, the resurgence of the importance of the corporate trustee is being driven by trust companies like Bridgeford, because we are willing to deal with assets that other trust companies don't want to do. You see, the reason why, and I said earlier, why is an individual trustee appointed all the time? Well, in some cases, the bank or the other large corporate trustee, they don't want to talk about, they don't want to deal with real estate. They want to be asset managers. They want to deal with they don't want to deal with real estate or closely held stock or insurance. Because again, for whatever reason, well, the directed trust statute says to us at Bridgeford, sure, we will absolutely hold those types of assets. And that's really what's needed right now. Not everybody has $25 million sitting in a portfolio, right, of cash. But what a lot of wealthy families have, or normal families, is their net worth is tied in where? Their real estate, their closely held stock, in some cases artwork or LLP interest. That's where their net worth is. That's the way it is in central Pennsylvania and Ohio and Southern California and in New York City and everywhere else in the country. Most people's net worth is tied up in either the company that they've started or inherited, or stock options they've developed, or some sort of concentrated stock. This is why I think this resurgence of the corporate trustee is so amazing right now. and again, frankly, so exciting. So very quickly, this is how it works, and we don't need to go too much into the details, but it splits apart. The directed trust splits apart the various functions and creates the ability for a distribution committee, an investment committee, and an administrative trustee. So it's the investment committee right there in the middle. You see stocks and bonds, insurance, arts, FLPs, LLCs, real estate. The trust itself establishes an investment committee, and the investment committee can be comprised of any type of family advisor, the settler of the trust himself, anybody who's close to the situation, and that committee directs who is going to manage the money. That's the name of it. That's why it's called a directed trust. So that committee directs a Bridgeford Trust Company to contact or work with an asset manager. Any asset manager they want to work with. So if they have a particular broker or RIA they like to work with or asset manager, they can work with that asset manager because that investment committee is going to tell Bridgeford to work with them. And so what administrative trustee as Bridgeford does is we own the assets, we maintain the bank accounts, we do all the traditional trustee services, but because of the liability bifurcation and because of these roles being established and split up, we are serving at the pleasure of these various committees, and so is the investment manager. So here we are now coming back to that word. This chart demonstrates just how much control these folks now have, these wealthy families, anybody who has any trust issues, or I mean trust and structure, not we all have trust issues, Tyler. But this is where, and I've said it so many times, but this idea of control is permeated through all these modern trust laws, and this is sort of a quick chart of how it all comes together. And I can tell you the clients we work with and the people that I talk to around the country love it. I speak a lot around the country, and this has really been the hallmark or the foundation rather of what has become a very dynamic trust industry. So decanting. This is another concept that is extraordinarily progressive. Not every jurisdiction has decanting. I'm not talking about wine, although once we're done here, perhaps we can talk about decanting some wine. Decanting here is actually just like in concept, decanting wine. It's taking, or as it says on the slide, distribution of assets from an irrevocable trust into a new trust with different and presumably more desirable and flexible provisions, leaving the unwanted provisions in the original trust and not binding on the trust assets. Okay, so what do all those words mean? Here's the example. A trust that was established 25, 30, 50, 60 years ago doesn't work anymore. The dispositive provisions are old. It was created at a time where life was different in America. Beneficiaries have changed. Or, more importantly, it's in a jurisdiction that's just not as good. It could be stuck in Pennsylvania. It could be stuck in New York State. It could be stuck in a jurisdiction that just isn't as progressive as a South Dakota or Alaska or others that we've mentioned. So decanting has emerged as this planning tool to be able to simply make changes without having to go to court, which is a huge, huge change in this country. We're able to take trust up until before this concept of decanting came about. Before decanting came about, it was very, very expensive to move a trust, to change the trust provisions, to get rid of a trustee, to basically modernize a trust. And that's not even to consider moving it to another trust jurisdiction that's better. It would have been a very, very expensive process. Along comes decanting, and actually, surprisingly enough, the first decanting statute was in New York State. And the idea is, and it's an acknowledgement on the part of legislatures around the country in various states, is saying, okay, listen, we know that trusts, that the world changes and that trusts sometimes don't change. We know there are different reasons for trust. We know that the reasons for establishing a trust 100 years ago just isn't the same. So we're going to create a way for families, particularly ultra-high net worth families, to just change the terms of the trust. So if we go to the next slide, we could talk about, why would we use decanting? To transfer situs, that's how we use it more than anything else. To move it to a more favorable jurisdiction, correct drafting errors, enable trusts to be subdivided among beneficiaries, switch from a grantor trust status for tax purposes to non-grantor trust. That's a big one that can really save a lot of money. You can change these trusts to insert asset protection provisions, Tyler, and how we just talked about, which a lot of folks want. We can change administrative terms of the trust, change the trustee. That's a very big deal right now because you have old trust companies that have been around forever. They think that people can't move their trusts. So they tell their clients these trusts can't be moved. Well, if you look at the decanting statutes in certain states, they absolutely can be moved to another trust company or another asset manager now. And these are relatively brand new ideas, well, brand new within the last 10 or 15 years. Expand trust powers. And, as I said at the end there, create a directed trust. So the idea of creating a directed trust, which again gives much more control, as we talked about, including asset protection provisions, and moving it to a more progressive trust jurisdiction or situs, radically changes the concept of what is an irrevocable trust. You know, when you say the word irrevocable, people think, oh, that's unchangeable, it's unmovable, it's rigid. And you know what? That's what it meant 40 years ago. But in 2014, with the advent of decanting, it doesn't mean that at all anymore. And it raises the question, are irrevocable trusts really irrevocable anymore? Which is controversial, and I recognize that some folks, people, advisors, planners, don't like that idea. They think that these trusts were established for a reason 100 years ago, and it isn't our place to change the important provisions of a trust or to move jurisdiction if that's not where the original intent was of the settler. But nonetheless, we have the powers now, whether we like it or not. It's here, and I tend to be excited about them because it gives much more flexibility and control. It introduces it into an arena that has not been able to be flexible in the past.
Dave, in regards to decanting, can you just kind of touch on, what are some of the advantages to having a corporate trustee, if you want to, do any, one of these bullet points that you touched on in regards to decanting your trust?
Well, thanks, Tyler. And that gets to the same sort of general issue as to why the corporate trustee has emerged so dramatically in the last 15 years. It has emerged in conjunction with these new trust laws. Without a corporate trustee with trust charter powers or trust powers in some of these jurisdictions, as we talked about, that are progressive, you're not going to be able to get asset protection trust capability. You're not going to be able to get a directed trust capability, or you're not going to be able to get to save on taxation, as we talked about. So, again, unless you have a friend in South Dakota or a friend in Delaware, you need a corporate trustee. And I should have said the idea of a corporate trustee being too expensive or being another reason why we shouldn't be doing this. I guess I said that wrong. Has been a traditional block for people using corporate trustees. The directed trust, as I indicated earlier, eliminates a lot of the liability on a trust company, which then eliminates the need for the trust company to charge a high fee because the likelihood of them getting sued is greatly reduced in these jurisdictions. So a fee that traditionally you would see at a Bank of New York Mellon or any type of corporate trust company that does not use directed trust is going to be significantly higher than a fee at a Bridgeford Trust or an independent trust company, because we acknowledge the industry has changed and we collaborate with investment managers. We don't compete with them. There's a novel concept, right? Collaboration in the marketplace is nice for a change. And we can combine fees, and companies like mine can combine fees with asset managers, or when we're not even with an asset manager, when we're holding closely held stock, non-traditional assets, as I mentioned, like real estate. Bridgeford and other trust companies like ours, we price it accordingly. We price it at a way that makes sense, that isn't onerous. And when you juxtapose a reduced price of a directed trustee, when you juxtapose that with the savings on the tax side and the advantages they get, it becomes a compelling option that totally wipes away the concern of a cost structure, and that's probably one of the things that we're most excited about. And we were met with surprise around the country. We were in Southern California, and we make presentations, and we get that question all the time about the fees. And when we come down to talk about fees, it's not onerous anymore. Now, I'm not suggesting that we do it for free, but we certainly do it we evaluate it a different way. So as we come to the end of our time together, I know we had a lot of concepts, and this chart may be a little difficult to see, But this is where the proverbial rubber hits the road. The vital importance of choosing the correct trust jurisdiction in the context of the reemergence of the corporate trustee is so important to consider. So the argument that we began with, the thesis of the presentation is, look, we're not your grandfather's trust company anymore. The trust laws have changed so much. The space is so dynamic. There's so much more control. And the reason why the corporate trustee has become important and relevant, again, in our view, is because of this jurisdiction issue. That's really the point here. The ability to select the correct jurisdiction. You need a corporate trustee to do so. And in addition to the advantages over an individual trustee that we started with, jurisdiction really is the foundation for this. And so this compares, and again, this isn't just the opinion of us at Bridgeford or the accounting firm or Tyler and Dave Warren. This is objective comparison. So South Dakota, Delaware, and we use Pennsylvania here, but Pennsylvania is pretty traditional across the country in terms of how most states are like Pennsylvania. But if you just look at South Dakota and Delaware, there's a real East Coast bias here where lots of folks can presume that actually Delaware is a better state for trust planning and trust situs, and quite frankly, objectively, that's really not the case. And again, that's not my opinion. It's the opinion of people probably far smarter than me. So, for example, in Delaware, there is asset protection. They both have domestic asset protection. The difference is there's something called fraudulent conveyance, which is a fancy way of saying look back. And South Dakota has a 2-year look back, and Delaware has a 4-year look back. So why does that matter? It means that when you establish a trust in Delaware, it takes 4 years before asset protection attaches. If you are sued or if there's a claim brought within the first 4 years, then you're gonna be subject to, you're not gonna have the protection of asset protection of the asset protection statute. However, in South Dakota, it's 2 years. I mean, that alone is very compelling. Both states, they don't tax, as we talked about, the trusts themselves. Trust privacy, there's the comparison there. We talked about total seal in South Dakota versus a 3-year seal in Delaware. And then as you look down this dynasty trust portion, I talked about others create charts and these very complicated rubrics to compare these states. While Delaware is also considered a dynasty trust state, it's ranked 7th right now, actually might be 8th, and South Dakota has been considered to be number 1. Not only by a chart put out by Steve Oceans, which is, you can see the reference there at the bottom, but also by most commentators would consider in many cases this, South Dakota to lead in that respect. Why does that matter? It matters importantly because we're talking about selecting the proper trust jurisdiction. So while I said there are 4 that are the best, and any 4 of them can accomplish a lot of your objectives, if we know that 1 or 2 states are a little bit better than the other 2 states that are considered top tier, why would we just not go there? And then we talked about directed trusts and there's the decanting statute that we talked about. That's also been evaluated. South Dakota has been considered to have the best and most flexible decanting statute, whereas Delaware's is not rated quite as high. So these comparisons matter in the planning process. We're very excited about it. We pay close attention to it, and we think that the details. I always like to use this analogy. Whomever knows the rules of the game the best, they're going to win. And so if you're great at chess, you're great at chess because you know the rules better. If you're a good planner and you can deliver the best possible results, that means you should know the rules better than everybody else. And knowing the rules of the game here, which is understanding jurisdiction distinctions and what decanting is and how a directed trust works and whether or not you can receive asset protection in the United States, understanding the rules of the game and understanding that through decanting you can accomplish all of these objectives. You can get access to all of these laws around the country, although you might not live in one of those states, is very compelling and something that I think we need to talk more about and spend more time on the education process. So I appreciate the opportunity to talk about a lot of these concepts. As I hope was evident, I'm very enthusiastic and passionate about what we now can do in this space. And the world has changed. It's changed dramatically, and it's changed a lot over the last 20 years. I'm happy to take any questions, and I would love to talk to you offline if somebody would like to contact me. You can check out our website. There's a lot more information about objective information that has been reproduced, and articles and videos and different things that go into these topics in more detail. But before we take some questions, I have to again reiterate: the world has changed so quickly that for advisors and any of us serving families of any kind of wealth, we need to understand this and stay current. And that's really the only way we're going to bring the best that we can to these clients. So, Tyler, thank you again. Tyler, I think we'll close this out. And again, we'll be happy to take any more questions.
Thank you again for joining us for today's webinar, Not Your Grandfather's Corporate Trustee, Modern Trust Laws and the Resurgence of the Corporate Trust, brought to you by McKonly Asbury. We will be sticking around to answer some of the questions that have come in, so please continue to submit them via the chat function, and Dave will be happy to answer them over the next few minutes. As a reminder, you will be receiving CPE credit for attending this 1-hour webinar. CPE certifications will be sent out via email within the next 15 days. Also, you will be receiving a follow-up email to this webinar with a link to a short survey about the webinar, and we would appreciate your feedback. We will be posting a copy of today's presentation on our website at www.macpas.com/news. Look for that post to be up in the next few days. Now, let's go back to Dave to answer the questions that have been submitted.
Thanks, Tally. I see we have some questions that have come in.
Yeah, Dave, the first question that we have here is, what has been your experience with moving trusts out of Pennsylvania and into other jurisdictions?
I sort of complained a bit earlier about how Pennsylvania is not really a top-tier trust jurisdiction and can be difficult to get access to some of these planning tools. But actually, it's remarkably easy to move a trust out of Pennsylvania into another jurisdiction. There's a specific law on the books that's not very old, but and somewhat obscure that indicates that you don't need to go to court to do this, as long as you have the sign off of the beneficiaries, which is to say that if all the beneficiaries can be contacted and they all agree, then jurisdiction can simply be moved to another more favorable jurisdiction. Now, even if we didn't have that law in place, however, remember we talked about decanting. That's another way of doing it as well, which is also relatively easy. There's a couple more steps, but it's been my experience generally that it has not been a problem. Certain Pennsylvania-based banks don't like it, but it's able to be accomplished very easily. Not a lot of expense, and actually remarkably quick. I mean, we can do it in the course of a week if necessary, if we can get the signatures.
The next question is, has an asset protection trust statute been struck down by any court?
No, we talked a little bit about that earlier. It has not, and this is a very, very important distinction that I want to make, and that's a great question. The statutes themselves have not been attacked in terms of their ability to provide asset protection. There have been some courts that have questioned that in some of their opinions, but no statute has been struck down. Where they have been challenged and where they have been, where the trusts have been pierced, is around the idea of a fraudulent conveyance. I talked about the look-back period and how important it is, and how every state's a little bit different, and how Delaware's is 4 years and Pennsylvania and South Dakota's is 2. If there's a fraudulent conveyance, which is to say that a conveyance is made in an outright attempt to hide assets. So, Tyler, if you know you're about to be sued and you move assets into an asset protection trust in South Dakota, that's fraudulent. And so the reason why there's a 2-year limitation in South Dakota and 4 is the presumption is that, well, if you don't get sued within 2 years or 4 years in Delaware, then you didn't know about it, right? That's kind of the idea. And so all the cases that you see, and there's a bankruptcy court case out of Alaska that really got a lot of it. Well, actually Washington State that challenged the Alaska Asset Protection Statute. They got a lot of attention, and some commentators said it challenged and raises the question whether or not an asset protection trust, whether they even work. Well, that's not the right analysis. It was a fraudulent conveyance problem. When that conveyance was made, everybody knew that there was a claim pending or about to about to happen. So when you look at those cases, I tell folks, be very careful. There has not been a single case that has struck down an asset protection statute. And so there's a lot of commentators who believe that if established correctly and administered correctly, they're generally impenetrable as long as you do it right and you don't try to avoid a claim.
Thanks, Dave. Looks like that is all the questions that we have. So do you have any final words for anyone still listening about, corporate trusts?
No, thank you for being here. We appreciate the opportunity. Again, we're excited about what has changed in the last 20 years and happy to answer questions. Please contact us. Feel free to go to our website. There is a blog post that you can sign up for, a blog email that we update frequently with information about changes in the trust industry and updates that have been proven to be helpful to folks in the industry. So thank you again.
Thank you once again for joining us for this presentation produced by McKonly Asbury, Certified Public Accountants. We hope you join us and participate in our upcoming events. You can stay up to date with news and learn about our upcoming events by visiting us at www.macpas.com. Thanks again and have a great day.